Sorry. Commissioner Payne,
Aye.
Commissioner Thompson.
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
I apologize, Chair Fiscom. The recording missed the motion that we were voting on.
Okay, thank you for that comment. Vice Chair, would you please make your motion again for the record on item number 43?
Yes,
So the
Chair.
recording can capture your words. Thank you. Please.
Sure, no problem. I move that the commission approve the executive session consent calendar as presented.
Thank you. The administrator will now call the roll on item 43.
I think we can count the roll call as it was
Did you hear the
previously done.
did the system catch the roll call? Okay, thank you.
I
So
apologize.
no, don't apologize yet. You can apologize at the end. That captures item number 43. Colleagues, we will now move to a collection of items, items 44 through 49, which all deal with the same issues in your executive session agenda. Those individuals so involved will now be admitted. You
Yes.
tell me when they're
Yep.
online.
And we literally have some people joining over the phone, so we just need to give it a moment of silence because they have some instructions as they join on the phone. So we just need to be quiet for them, but letting them in now. Everyone, so we have Sarah Henderson attending, Corin Funderburg attending, excuse me, and Darren Duflock and Roke Kenneth in the room.
There may be others who might be joining. Is that
Yes,
fair?
they did not confirm and we do not see them in the room right now. So,
So we can proceed.
yep, and their mics should all be working, so they should be able to hear us now.
Okay, colleagues, the context here is that we'll consider these items together involving the city of Umatilla, items 44 through 49. Just for the record, all those individuals involved who are appearing together have waived confidentiality, so we can consider the issues together, and eventually we'll go beyond that for one individual who has not waived confidentiality. That said, our approach on these matters for those appearing before us, as well as for the room here in Salem, is that we will consider this in 5 parts. First of all, we'll hear a report from our investigator, Mr. Pacheco, on these issues. Secondly, we will ask him questions if commissioners have questions. Thirdly, we'll turn to you, folks who are online with us, in case you choose to make any comments to us, which you are free to do. The only quick thing I would indicate is that we have a long agenda today, so we're going to be pressed for time, and that allows me to encourage you to be brief and to the point in your comments to us if you choose to make them. So thank you for that consideration. Next, fourth, we may have questions for you that we'll ask, and fifth, the commission will move toward a decision on these matters that are before us. So that said, please, Investigator Pacheco, please proceed.
Their attorney does have their hand.
Oh, the attorney, Ms. Henderson, you have a question quickly before we proceed? I see your hand raised, Ms. Henderson. I should have recognized you as being part of this process. You're the attorney of record here. Do you have a comment to make? I'll assume your comment can hold. Investigator Pacheco, please report on these matters in one report for all. Thank you.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda items 44 through 49 in your meeting book are preliminary review reports for the City of Umatilla City Council. Public meetings law permits members of a governing body to convene an executive session to consult with counsel concerning litigation or litigation likely to be filed, and to consider the dismissal or discipline against a public officer who does not request an open hearing. In this case, City Mayor Caden Seif alleges that the council made a decision regarding the number of violations filed against him at the October 15th City Council executive sessions. Based on the information gathered, it does not appear that the council made a decision at the executive sessions. Rather, it appears that the council reached an informal consensus on the allegations filed against Mr. Seif based on the advice of council. However, the consideration of confidential information or records is not covered under ORS 192.660 sub 2H, but rather 2F. Thus, further information is needed to determine whether the council's discussions under this provision were authorized. Additionally, it appears that the council failed to provide a true reflection of the matters discussed at either executive sessions or record the votes of each member by name during the public portion of the meeting. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that on October 15th, the Umatilla City Council violated ORS 192.650 sub 1 and 2 and ORS 192.660 sub 2. The recommendation in your books is to move this case to investigation. Thank you.
Investigator, thank you. Appreciate your report. Colleagues, any questions for our investigator before we proceed? Hearing and seeing none for the moment, no hands raised that I can see. We'll now proceed to the time when individuals appearing before us have a chance to make comments to us.
Commissioner Fiscom?
Please.
I just got an email from Ms. Henderson. It looks like she having issues unmuting her mic. She does not have a working mic and cannot turn it on.
Cannot turn it on.
Yeah, I'm not exactly sure.
She just left the room and came back in, so let me try.
We'll pause again just for a moment.
She's back in. You can see.
Okay, who's with us now? Repeat the names of those with us. Miss Henderson is with us.
Miss Henderson, Darren Duflaw, and Roke Tenick.
Okay, and not the McMillans.
Yeah, not
and-
McMillan's, not Wheeler,
Not Wheeler.
and Thunderberg. Their number is there, but they did not.
Okay, thank you. Okay, those appearing before us, thank you for your patience with this process. The names I have of this group that are appearing with us include Sarah Henderson, Darren Dufloth, and Roke Tenick. If I've said that name wrong, I apologize. And now is the time for you to make any comments you choose to make to us. You don't all have to speak, so we'll leave the order to you. If you choose to speak to us, identify yourself for the record, and please proceed as briefly and to the point as possible. Who's first? Ms. Henderson, are you going to speak first? You can't unmute. Maybe. Okay, pending that, let's proceed to Mr. Dufloth.
Well, no. Sarah Henderson, if your mic isn't working, you can call into the number on your phone and connect the audio that way.
Thank you, Ms. Henderson. We'll assume you're going to call in. For the moment, we'll proceed with, if you'll allow us to proceed by giving Mr. Dufloth a chance to make any comments to us. Mr. Dufloth, if you have a comment, please proceed.
No,
I do not have.
not compliant.
Okay, thank you. Ms. Henderson, are you on the phone yet?
She's going to try calling in.
Thank you. She's going to try to call in. So Mr. Tenick is not speaking either. Is that fair, Mr. Pacheco? If you can tell. Thank you. That's all. Yeah. Ms. Henderson, as soon as you can hear me on the phone, please proceed. We'll allow you a moment to.
She hasn't joined yet via phone, Sarah Fiscom.
Okay.
We'll let you know once.
Thank you.
Technology is the bane of our existence.
Makes our lives easier.
Those remarks are now online.
The sarcastic tone was. Please note for the record, in parentheses, it was made sarcastic.
Only to the website.
so we're admitting her. Let me really quick allow her mic.
Ms. Henderson, can you hear me?
You might have to press *6 to unmute. It will show you unmuted, but I don't.
Can you hear me?
Yes.
Please say another sentence. Introduce yourself for the record and we'll proceed in a moment. Go ahead.
Yes, good morning. Sarah Henderson here on behalf of the Umatilla counselors. Can you hear me all right?
Thank you. You're coming in now. Thank you for your patience and we're thanking ourselves for our patience. I'm glad we can now hear you. I understand that you're prepared to speak for several of these individuals involved on behalf from the city of Umatilla. If you are so prepared, please make your comments for the record now. Introduce yourself for the record.
Yes, thank you. Sarah Henderson, like I said, for the individual city councilors. I did have a quick question as I was trying to speak up before regarding confidentiality. There was a comment about that many had waived confidentiality, but one had not. And I was wanting to clarify because on behalf of my clients, we did not. We have no issue, obviously, hearing these issues together amongst them, but not waiving regarding executive session. Is my understanding correct?
Executive, please.
So the waiver was a limited waiver to allow each of these cases to be heard at the same time. So that it was limited to waiving confidentiality, so you're all in the same room hearing the cases. In terms of the executive session, you do need to be aware that under the commission's rules, our executive session becomes public as soon as our meeting is adjourned, meaning the recordings of this executive session do get posted to our website.
Understood. Thank you so much.
But the materials,
I appreciate.
yeah, any confidential materials remain confidential in terms of the records that we may have reviewed.
Understood. I appreciate the clarification. Thank you. That clarified, I guess I will keep it very quick. I don't have a ton for you. I think that the preliminary review regarding the complaint itself as to the executive sessions and notice and all of that was very thorough. I would like to make a few comments just as to context. I know that as an earlier complaint that was opened against Mayor Sipe, who is the complainant in this case, there was sort of some commentary about the situation, the larger situation that's going on with the council and the mayor for the city of Umatilla. And I just wanted to clarify on behalf of my clients, we've got a little more complicated situation than I think has come up so far, and that is a very much and what seems to be an attempt at ousting the city manager, as opposed to an attempt to oust the mayor. I just wanted to clarify that for you all, for the commission, to understand sort of the complexity of the situation going on. I'd also comment that I know I clarified this with Mr. Pacheco, and I appreciate being able to speak with him, that the city attorney, John Stride, does not represent these individual counselors. That is me at this point. And I would clarify that that's because there is litigation pending now between the complainant in this matter and the individuals that I represent. So for purposes of that consideration, I just wanted to make clear that to the extent my individual clients have adopted the city's version of events as their official statements, that is not a representation situation. That information provided by the city attorney was the official position of the city. The other thing that I would go into really quickly is the sort of related issues of the audio that was being captured or not captured in prior meetings. And in conjunction with that, the apparent lack of roll call votes that was occurring. I I would encourage, obviously I would ask at this point, because what the topic or the underlying circumstances of this case really have already been resolved. And I would point to the fact that in the most recent council meetings, you will find, if you were to review them, that the audio is much improved. It can be heard what's being said throughout the meetings, and there are roll call votes being taken. So to the extent that my understanding is the commission exists for the noble purpose of helping all of us, figure out what the right way to do this is and make sure that we rectify it and do it correctly. Fully heard that there were issues with the audio, and that has been fixed. The roll call vote scenario has been fixed. So I would ask that issue sort of be mooted at this point. The last issue being the question of whether there was a vote taken or a decision made in executive session. I think that's pretty clear. We, at this point, as of March, we have active litigation filed against these individuals and the city by the complainant in this case. That litigation had been contemplated for many months and expected to occur. And so that meeting, in our position is that meeting in executive session with the city attorney, John Stride, and the advice by the city attorney not to even look at one of the complaints that was being made was strictly a discussion of threatened litigation because there were First Amendment issues involved. So that's what would be our position, that executive session was proper, that there wasn't anything considered beyond the advice of the city attorney that was present there. And then also on that topic, I think it bears to keep in mind that these executive sessions were being held with the city attorney on site directing traffic. And while I know this has been mentioned to you before, it's not an excuse, but it is I think relevant to consider that when you have council there directing traffic and in the moment telling the council what they can and cannot do in executive session, that's relevant to a finding of a violation on behalf of the individuals. That said, I appreciate your time, and I would be willing to answer any questions that the commissioners have. And to the extent my clients can answer or would like to answer questions, I will allow them to. But at this point, that's what we've got for you. Thank you. Thank you again for
Ms.
your time.
Henderson, thank you for your appearing before us today, for your comments and for your patience with all this technology issues that we're dealing with. The fourth step in our process is for commissioners to ask you any questions that might have arisen in light of what you said. Thus, commissioners, any questions for Ms. Henderson? Okay, I'll assume that there are no questions at the moment. The time is now for us as a commission to move toward a decision on these matters, which will be conducted individually. My only question, Investigator Pacheco, is if this has been reported in your documents. I apologize for asking the question. If you were to summarize what it is, if we decide to move forward, what you would focus on, that would be helpful, please.
Thank you for the question, Commissioner Fiscom. The issue in this case is that it appears that the council was discussing confidential records / information under 2H. So I would need to just staff this case with DOJ or the executive director to clarify how to move forward, whether those discussions were prohibited under 2H. So that's about it.
Thank you, Director.
So the question is 2H's discussion of the public body's legal rights and duties with respect to current litigation or litigation likely to be filed. Often when there are attorneys involved, that can blend into what is more appropriately cited under 2F, which is consideration of confidential record information or records. So like confidential attorney-client privileged advice would fall under 2F. It's only if it's advice relating to the public body's rights and duties that it would fall, with regard to litigation, that it would fall under 2H. So we would potentially need to simply look into that issue a little further to draw a conclusion whether, given the other litigation stuff that was going on with this council or the counselors, whether what was discussed in this executive session truly would have fallen under H or should it have been F. And then the other things are the the minutes and so forth.
Thank you, Executive. Any questions, colleagues, for the executive or our investigator? Any further questions? Hearing and seeing none for the moment, the opportunity now exists for us to move toward a decision on the matters before us. I'm open to questions about how to proceed as well as eventually a motion. Looking and seeing if there are hands raised or anybody have any comments or questions or a sense of direction for us. Hearing and seeing none, Vice Chair, are you prepared to make a motion? Please.
I am, and just so I understand, I thought there was one person who did not waive confidentiality in this group. Do we need to do that one separately?
We'll take a vote separately on each of these matters. The only individual who will appear on item number 50 on our agenda is the mayor, Mr. Sipe, and he's not part of this first batch of consideration for the council. Otherwise, I think for purposes of the limited confidentiality waiver that we're talking about, everybody else is waived. Am I right, Director?
Yes, and it is up to the commission whether you want to vote on all of these or whether you want to pause these, hear from Mr. Sipe, and then come back to these. You can do it either way.
Colleagues' preferences, we could vote on these matters and then proceed to consider separately the issues involving Mr. Sipe related to these issues in some ways simply because of the city of Umatilla. I'm open to suggestions on how to proceed. I, for one, would be happy to make a decision and proceed to Mr. Sipe secondly.
That's fine.
Please, Mr. Thompson, please.
I was just going to agree with you. It sounds to me like we have a subsection discussion to have, and
Right.
that sounds like we're going to have that discussion regardless of the order. So,
Yeah. Vice Chair, please.
Okay, thank you.
This and the motion pertains to item 44.
Yes, thank you, Chair. I hereby move that the commission finds that there is a substantial objective basis for believing that Ashley Wheeler may have violated ORS 192.650 subsection 1, ORS 192.650 subsection 2, and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. Colleagues, you've heard the motion. Any questions on the motion before us now? Hearing and seeing none, the administrator will call the roll. Item 44.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Thompson,
aye.
Commissioner Payne,
Aye.
Commissioner Mettler,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Hey, colleagues, we'll now move to item number 45 involving Karine Funderburk. Vice Chair, please.
I hereby move that the commission finds that there is a substantial objective basis for believing that Karine Funderburk may have violated ORS 192.650 subsections 1 and 2 and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. Hearing any questions, hearing and seeing none, the administrator will call the roll. Item 45.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCully.
Aye.
Commissioner Payne,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Colleagues, item 4.6 involving Mr. Darren Dufloth. Vice Chair, please.
I hereby move that the commission finds that there is a substantial objective basis for believing that Darren Dufloth may have violated ORS 192.650 subsections 1 and 2 and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you. This is item 4.6. The administrator will call the roll, please.
Commissioner McCully,
Aye.
Commissioner Mettler, Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Colleagues, item 4-7 involving Ms. Katie McMillan. Vice Chair, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Kate McMillan may have violated ORS 192.650 subsections 1 and 2 and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. The administrator will call the roll. Item 4-7.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Payne,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mason,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Colleagues, item 4-8 involving Mr. Dennis McMillan. Vice Chair, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Dennis McMillan may have violated ORS 192.650 subsections 1 and 2 and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. The administrator will call the roll. Item 4-8.
Commissioner Payne,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mettler, Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Colleagues, item 4-9 involving Mr. Roick Tinick, if I'm saying that name right. Vice Chair, please. Item 4-9.
I hereby move that the commission find that there is a substantial objective basis for believing that Roick Teniak may have violated ORS 192.650 subsections 1 and 2 and ORS 192.660 subsection 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. The administrator will call the roll. Item 4-9.
Commissioner Thompson,
Aye.
Commissioner Mettler, Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Thank you, colleagues. Ms. Henderson, thank you again for your appearance before us this morning and for your comments. We appreciate it. For the record, while we have taken action in the matters involving your clients, please understand the following. Nothing we have done today has found there to be an actual violation of anything. We've simply indicated the need for more information of the sort described by our investigator and our executive. So now we'll proceed in that direction. Our staff will be in touch with you, and thank you again for your patience with this process this morning. We appreciate your participation. Thank you.
Thank you as well. I look forward to helping you get the information you need.
Thank you. Okay, colleagues, with those people being removed from the process, we will now wait until we're ready for item 5-0, which will involve two individuals. First of all, Mr. Caden Sipe, who is the mayor of the city of Umatilla, and his counsel, who has said he will be on, Mr. Nathan Reitman. If I'm saying that name right, both of them have indicated their intent to appear today separately from city councilors. So we'll await their arrival.
Okay, both are in the room.
Thank you. Mr. Reitman, can you hear me? At the moment, it appears to me that you're on mute, Mr. Reitman, if you want to unmute yourself.
Yes, I can hear you.
Thank you very much. Mr. Sipe, are you on today as well? Mr. Reitman, will
Yes,
Mr.
I am.
Sipe? Oh, thank you, Mr. Sipe. Can you say something for the record so we can decide whether we hear you or not?
Yes, sir. My name is Caden Sipe. I am here as well.
Thank you. Thank you very much. Okay, this is how we're going to proceed this morning. For the record, my name is Dave Fiscum. I'm the current chair of the Oregon Government Ethics Commission. Our process today, thank you for being with us today and dealing with technology with us and for us, will be fivefold. One, we'll hear a report from our investigator about the matter before us. Secondly, we'll ask questions for our investigator. Thirdly, we'll turn to you to make any comments you choose to make to us. In regard to that, please understand that given a very tight agenda today, we may hold you to about 3 minutes each if you choose to speak to us. The point of which is simply to have you emphasize the points that are important for our consideration. Fourthly, we may have questions for you. And fifthly, we'll move toward a decision. So that's how we'll intend to proceed today. I'm thankful you can hear us and we can hear you. That said, our investigator is Daniel Pacheco. He'll now make a report to us. Mr. Pacheco, please proceed.
Thank you, Chair Fiscom and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 50 in your meeting book is a preliminary review report for Caden Sipe, Mayor for the City of Umatilla and a member of the City Council. In his self-reported complaint, Mr. Sipe alleges that on October 15, 2024, the Umatilla City Council made a decision regarding a complaint filed against him in an executive session. Based on the information gathered, it does not appear that the City Council made a decision, but reached an informal consensus based on the advice of the city's legal counsel. However, it does appear that Mr. Sipe and the council failed to provide a true reflection of the matters discussed at the October 15th executive session or record the votes of each member by name during the public portion of the meeting. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Mayor Sipe violated ORS 192.650 sub 1 and ORS 192.650 sub 2. Commissioner Brooks is to move this case to investigation. Thank you.
Investigator, any questions for our investigator from commissioners? Hearing and seeing none, the time is now. Mr. Reitman, if I'm saying your name right, if I'm not, please correct me. Mr. Sipe, please make your comments to us. You may proceed in any order you choose, and we'll hold you to a time limit. And please, before you start, say your name for the record. Please proceed.
Yes, it's Nathan Reitman, and I'll just kind of highlight a few high-level points for you. The first is that, Mayor Sipe is the person who initiated this complaint. I know that doesn't necessarily mean that he's not culpable, but I think that is a very significant fact. Another significant fact is that he ran for public office. His main campaign theme was that they needed to have timely and accurate minutes. The facts will show that he advocated with city staff from his first day in office, in fact, even before, that they needed to be doing the minutes correctly. He was consistently advised by the city manager and the city recorder that everything was being done properly, and his concerns were unwarranted. Those individuals are, supposed to be experts in their field. His control over this situation is completely limited. As the mayor, he doesn't vote on whether the minutes are approved in the event of a tie. There's no evidence that ever occurred that would differentiate him from the other council members. And while it might be said that, the mayor has some authority to set the agenda, the longer factual record associated with this circumstance will show that, his effort, he has not, as a de facto matter, had the ability to set the agenda for the meetings and make, proper conduct of the minutes an issue that is addressed. And even if he did, the advice that he's been given from key city staff is that everything is being done correctly and his concerns are unwarranted. I think the other thing too that's important to emphasize is that, there's only been a few circumstances in his tenure when there have been roll call votes and it wasn't just a unanimous vote. He has called for a roll call vote in those circumstances. It just has not been properly recorded. So I think, under the totality of the circumstances, it's kind of contrary to public policy to have the person who initiated the complaint, who has been trying to get this done properly since the first day in office, end up as the person who is sanctioned for the conduct at issue. So that would be the extent of my comments.
Thank you, Mr. Reitman, and I apologize for mispronouncing your name a few times before your appearance. Thank you for appearing before us this morning. Mr. Sipe, do you have any comments to add for the record? If you do, identify yourself for the record and please proceed.
Thank you. My name is Caden Sipe. And I just want to really agree with what representations just mentioned. On the times, exactly what he said, on the times that I have heard dissenting votes, I do request a recall. But to my memory, we've had 2 dissenting votes. And during that time, I've asked for a roll call vote. Not a recall, a roll call, sorry about that. But asked for a roll call vote. And that's the only times I can think of that I've actually heard. But once again, city staff has advised me that we don't need a roll call. And and I've just stuck with what city staff has told me that I needed to do, and I've stuck to it. And upon reading the investigation notes, I've actually adjusted policy already within the city, and we've moved forward. Thank you for your time.
Thank you, Mr. Sipe. Colleagues, now is the time for any questions for Mr. Reedman and Mr. Sipe. If any questions exist, please ask them at this moment. Colleagues, commissioners. Hearing and seeing none, the time is now for us to move toward a decision on this matter. I'm telling Mr. Sipe as well as his counsel, Mr. Reedman, any questions or suggestions about how to proceed? Colleagues? Let me ask you the question again for the record, Mr. Pacheco. Would you summarize again what it is, if we chose to move forward today in a few moments, what it is you'd focus on?
Thank you for the question, Commissioner Fiscom. If the case moves forward, there's nothing further to review. I would probably be a letter of education for Mr. Sipe.
Thank you. The likely result, as you've heard, perhaps is a letter of education from us to you if we were to proceed. We do not have the freedom at the moment to direct issuance of such a letter. If we proceed today, I will say something preceding that vote is if we proceed in the affirmative, that does not mean we have found there to be a violation. It's only a need for more information for our process. So thank you for your appearance today, Director.
Vice Chair Payne.
Oh, Vice Chair, I didn't see your hand. Please proceed. Ask a question, make a comment.
Thank you. I just have a question for Investigator Pacheco. I'm just a little confused on the facts here. It appears to me that Mayor Sipe left and did not attend the executive session. And so I'm wondering if you could clarify, maybe I'm missing something. Were there more, is there more than one executive session at issue for which there are violations? Because I understood that he did not attend the executive session at issue.
Thank you for the question, Commissioner Payne. So the issue is that as a member of the governing body, Mr. Sipe is responsible for the proper recording of the minutes, the information provided in the public portion of the meeting and the executive session, just like a member is responsible for properly posting an agenda. So because he's a member of the governing body, he's responsible for making sure that that information is properly recorded.
And I would simply add, if you note the statutes for his,
It was
it did not include the 660 violation because he wasn't there for the discussion that may have been unauthorized. I believe the notice on the agenda included that, but realistically, the only violations that he would potentially be responsible for would be the minutes and recording violations, not what was discussed.
Okay.
Follow up, Vice Chair, please.
Okay, because I'm looking at the agenda and it includes all the same statutes as everyone else. So I may be confused, but I don't see that it's different for Mayor Sipe.
I believe that was our error on the agenda.
Okay.
But the 192660 should not have been included.
That is correct.
Yeah.
That is correct for the record. Vice Chair, thanks for the catch on your part. Any other questions or comments before we proceed? Thank you for the question, Vice Chair. The time is now for a motion if you're prepared to make one on this matter, item 50.
Okay, thank you. With that clarification, I am prepared to make a motion. I hereby move that the commission find that there is a substantial objective basis for believing that Caden Sipe may have violated ORS 192650 subsections 1 and 2, and that the commission should investigate accordingly.
Thank you, Vice Chair. Any questions on the motion before us, colleagues? Commissioner Thompson, please.
Thank you, Mr. Chair. I understand the statutory obligation of public officials they have to make sure everything happens and it's their responsibility. But I hope that assuming we move forward with this, I hope that we take into consideration that the mayor here took many steps to comply with his obligation. So, I mean, I understand there may be a need to flesh out a couple things as we move forward, but I hope that we take into account that he self-filed the complaint and that he has flagged these issues for staff in the past.
Yeah, Commissioner, good comments. I plan to endorse them for what that's worth, something. Colleagues, any other comments before we proceed to a vote on item 5-0? Hearing and seeing none, the administrator will call the roll on the vote before us to proceed with item 5-0.
Commissioner McCauley,
Aye.
Commissioner Mason,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Mr. Reedman and Mr. Sipe, thank you for your appearance before us this morning. We're thankful for your patience with various aspects of technology. Please understand that while we have decided to proceed, the likely result of proceeding is a letter of education. I want to thank you on the record for all of your efforts to make this right along the way and for changing aspects of your council deliberations and rules to bring them up to speed in light of what you've heard from us through all this process. So thank you for your due diligence. I appreciate it. That's it, gentlemen. Thanks for being here, and we'll sign off, and you'll expect to hear from our staff shortly. Thank you.
Thank you.
Thank you.
Okay, colleagues, thank you for those processes. Any questions about where we're heading next? And I'll tell you where we're heading next, so you know. We're going to head here items 51 through 55, the same report from our investigator. The only individual who's appearing before us, based on contacting him in advance, is Mr. Warden, one of the 5 subject to this issue from Klamath Falls Fire District 3. So awaiting his arrival online with us. We'll proceed as soon as we know he's there.
Also, he does go by Dusty, just so you know.
Pardon me?
They go by Dusty.
Mr. Warden does.
Yeah,
Yeah, thank you. Mr. Warden, are you with us this morning? And if so, can you hear me? Our records show you to be muted right now. If you can unmute yourself, that would be helpful.
Is that better?
That is better, Mr. Warden. Can you hear me?
I can, thank you.
Thank you. And I understand, Mr. Warden, you go by the name Dusty?
Yes, that's correct.
Okay, thank you for being here this morning. For the record, my name is Dave Fiscom. I'm the current chair of the Oregon Government Ethics Commission. This is the time set aside to hear matters involving the Klamath Falls Fire District number 3. For the record, there are 5 items before us, all related to the Klamath Falls Fire District number 3. You're the only one of the 5 who has indicated your intent to appear today. Let me tell you how this is going to proceed. The first step will be for us to hear from our investigator on the matters before us. Second step, we'll ask our investigator questions if we have questions. Thirdly, we'll ask you to make a brief statement to us for the record if you choose to do so. If fourthly, we may have questions for you. And fifth, we'll move toward a decision. That said, I'm glad you can hear me. Our approach today will start with a report from our investigator, Investigator Casey Fenstermaker. Please proceed.
Thank you. Good morning, Chair Fiscom, Commissioners. I am Casey Fenstermaker. Agenda items 51 through 55 are preliminary review reports for the governing body members of the Klamath Falls Fire District number 3. The complaint in this case alleged that the Fire District Board meetings on November 21st, 2024 and December 19th, 2024 were not made accessible to the public through remote means. Public meetings law requires governing bodies, to the extent reasonably possible, to provide the general public with the ability to access and attend meetings by telephone, video, or other electronic or virtual means. Commission staff confirmed that the meetings in questions were not accessible remotely. The fire district board members expressed that they were working to make the meetings electronically accessible, but that due to cost and equipment constraints, they were not able to offer a virtual option until the January meeting, in which they offered it by telephone. In anticipation of this meeting, one of the board members reached out to me and advised that they have since moved to Zoom. The recommendation in your meeting book is to move this matter to investigation.
Thank you, investigator, colleagues, commissioners. Any questions for our investigator based on her report just made? Any questions? I don't see a hand virtually or in the room. That said, we'll now move Mr. Warden to a chance for you to make any comments you choose to make for the record. Please understand the following. We're going to hold you to a fairly tight 3-minute time limit today because of our long agenda. That said, we're happy to allow you to make any comments you choose to make to us. And if you do so, please indicate your name for the record.
Yes, my name is Dennis Worden. I'm Vice President of the Board for Klamath Fire District 3. Essentially, the report is accurate. We did not have the means to do telephone or video access to our meetings at the time. In the process, I found a free conference call and donated a microphone to the system. So for the January, February, and March meetings, we were available via audio. And finally, our finances have turned around a little bit. We have purchased an OWL, which is a video conferencing system, and that is now officially online as of the April meeting. So that's just kind of where we are. Just want to let you know that we had made progress and that we intend to keep this thing going as best we can.
Thank you, Mr. Warden. I appreciate your comments and the summary of those sentiments from you and your colleagues. Any questions for Mr. Warden, colleagues? You're hearing and seeing none. Now's the time to move toward a decision on these matters before us, which we'll do individually, involving Mr. Hudson, Mr. Warden, Mr. Duncan, Mr. Matthews, and Ms. Guerreau, if I'm saying those names right. Colleagues, any intent about how to proceed today or suggestions thereto? Oh, pardon me, Vice Chair, please.
Yeah, I just have a question for Mr. Warden. I noticed in the materials that it said that there was a cost issue in relation to this and that the individual board members were using their personal funds for this. Is that correct? That you had to use your personal funds to provide this remote option?
Well, we used personal equipment. The laptop that the fire department had no microphone, camera, or speaker. And I provided a microphone and found the free conference call software that we could use to make this happen. So yeah, we were literally bouncing checks prior to the January 1st timeframe. So it was pretty tight for us.
Vice Chair, please follow up.
Yeah, I mean, obviously, I think that's something that should be taken into consideration. At some point is the just logistical issues that they were facing. I obviously, I think they still need to comply, but I think it's harder for some districts to afford to buy the technology than others. And I don't think that means it's not a violation, but I think down the road when we consider the consequences or penalties, I think we need to consider what it costs and how hard it is for some of these districts to comply. And that's my comment.
Thank you, Vice Chair. I want to associate myself with your remarks because as we deal with a lot of, no offense, small agencies around this state, like this one, I think we have to take that into account very quickly. That's very different than the city of Portland, the city of Salem, or other more major entities which have more wherewithal, however tight those budgets are. So it's a very good point Mr. Warden has made, and I want to associate myself with your remarks, Commissioner, for the future. Any other comments? Mr. Thompson, please.
Thank you, Mr. Chair. I guess I'm in my non-lawyer brain, I'm hung up on reasonable, and I don't know if they don't have the money to do it. Are we, is it not reasonable to expect us to do it? Because they don't have the money, they don't have the money. And it sounds like they have taken steps now to correct this, so I don't know what we gain by moving forward with this.
Your comment, Commissioner Mason, I see your hand, please.
Yeah, I would support a motion to dismiss this based on what we've heard. I'm not making the motion. Sounds like Commissioner Thompson might be leaning in the same direction, but not to put him on the spot. But yeah, I would definitely support a motion to dismiss. Thank you.
Thank you, Commissioner. I appreciate your comments. This may be heading in that direction, I surmise, as your chair. Any other comments, colleagues, on what you've heard in the last moments? Yeah, I, for one, in light of the reality of this situation, would favor the dismissal along the lines of Commissioners Thompson and Mason. Commissioner Vice Chair, are you prepared to make that motion, or should we go elsewhere?
It sounds like there may be consensus, and I'm happy to make that motion.
Please do.
Okay, on 52?
51, please, first.
Okay, start with 51 first. Okay, just wanted to clarify. Thank you, Chair.
Thank you. No, thank you.
I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Dan Hudson has violated ORS 1926703A or warrant further review, and that this complaint be dismissed.
Thank you, Vice Chair. Comments on the motion before us, colleagues? Hearing and seeing none, the administrator will call the roll. Item 5-1.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Mettler,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you, colleagues. Good discussion on that matter involving the same as the next four. So with that, we'll proceed to item 5-2. Vice Chair, please.
I move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Dennis, aka Dusty Warden, has violated provisions in ORS 1926703A or warrant further review, and that this complaint be dismissed.
Thank you, Vice Chair. The administrator will call the roll. Item 5-2.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
You will move now to item 5-3. Vice Chair, please.
I move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Cameron Duncan has violated ORS 192.670 subsection 3 subsection A or warrant further review, and that this complaint be dismissed.
Thank you, Vice Chair. The administrator will call the roll. Item 5-3.
Commissioner McCauley,
Aye.
Commissioner Mettler,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Item 5-4. Vice Chair, please.
I move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Dave Matthews has violated ORS 192.670 subsection 3 subsection A or warrant further review, and that this complaint be dismissed.
Thank you. This is item 5-4, right? The administrator will call the roll. Item 5-4.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Payne,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mason,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. We'll now move to item 5.5. Vice Chair, please.
I move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Carrie Garreau has violated ORS 192.670 subsection 3 subsection A or warrant further review, and that this complaint be dismissed.
Vice Chair, Administrator will call the roll. Item 5.5.
Commissioner Payne,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. That concludes the items on this agenda. Mr. Warden, Dusty, if you will. Thank you for being with us today. We appreciate your comments. The items before us, including the matter involving you, have been dismissed, and thank you for your due diligence in trying to follow Oregon's law as best you can. We appreciate your patience this morning with our agenda. Thank you for being here.
Thank you, and I appreciate the everything you guys do.
Thank you, sir. Have a good day.
Bye.
Hey, colleagues, let's forge ahead on the agenda with everybody's leave. One more category to consider before we move to a quote, as we say in our lingo, bio break. That's for Commissioner Mettler, who didn't know what that meant before I said it. We'll now consider items 5.6 through 6.0, which deal with Multnomah County School District 51J. In this matter, 4 individuals, Ms. Rosenbaum, Ms. Leninga, Ms. Sticklin, and Mr. Dominitz, if I'm saying that right, have agreed to waive confidentiality for the limited purpose of considering these items before us. The last individual on your list online, Kevin McPherson, has not waived confidentiality, so my approach today, subject to the executive's concurrence, is to move ahead with these 4 items where confidentiality has been waived. Hear a report, then hold off on a decision till we hear from Mr. McPherson separately, and then make decisions on all 5 of these matters. Does that meet with your approval, Executive? Okay, the staff will now admit those 4 individuals to us to appear together.
It's only 2 that I'm going to be admitting, just 2 that are showing up, Rosenbaum, and it's actually Strickland, according to their name. So there's an R there.
Okay, so who's going to be with us is Mr.
Rosenbaum and Strickland.
Strickland, and
Yeah.
the others aren't going to be, so I don't
they're
have
not
to
gonna be.
mispronounce
No.
Mr. Jeff's last name
Yeah.
again. So thank you for that.
On mute while we admit folks.
Please let us know when you're ready.
Both of them are in and have their mics and cameras for the team.
Okay, Ms. Rosenbaum, can you hear me? Ms. Rosenbaum, can you hear me? Your mic may be muted. Ms. Rosenbaum, your mic still appears to be muted. There's your hand is raised. You may have a question for our staff. Ms. Strickland, can you hear me?
I can.
Thank you. Hang on for a minute while we resolve our technology issues. Thank you for being here. Just hold for a moment.
Ms. Rosenbaum, are you able to take yourself off mute or not? It looks like you're joining through the computer, so you would have to adjust your mic at the top menu bar.
Ms. Rosenbaum, we see your hand raised, so I'll assume that means you will need to talk to us at some point about how to participate with us. The option is to unmute yourself on your laptop, or subject to our staff's counsel, to use your phone instead to make contact with us. We'll go on hold just for a moment to see if we can get you online with us. Ms. Strickland, please, you have a comment?
Ms. Rosenbaum has texted me and said she can't turn on her mic. It says on hers, it says select people can unmute only.
Okay. So the option for her is to use the phone, which our staff will help her to use in the next few moments, rather than to do the laptop.
Yeah, so she'll want to use her phone to call in then. The phone number we can put in the.
Well, I'll put the phone number in the chat to make it easier.
Ms. Rosenbaum, if you couldn't hear that, the phone number you can use to call in and get online with us, at least by phone mechanism, will be in the chat. And you might just look to see what the phone number is before you call it as quickly as you can, please. Ms. Strickland, please.
She
Comment?
texted, she said, I will call, so I believe she heard you.
Thank you very much. Appreciate it. Anything?
Not yet.
We may wait just a moment to see if Ms. Rosenbaum can access us in some way.
She's joining now, so.
She is joining. We'll see if that works. Is that her?
Yep.
Ms. Rosenbaum, can you hear me?
You may need to press *6 to unmute on your phone.
You didn't hear that on your phone, press *6. We'll see if you can hear then.
Yes, can you hear me now?
Ms. Rosenbaum, ask me again. Can you hear me
Hello?
again? Repeat that.
Yes.
Yes, I can hear you.
Thank you very much. Okay, online colleagues, either in one case through Teams, in one case by phone, we have two individuals who are appearing before us today in relation to items involving Multnomah County School District 51J. Those individuals are Michelle Rosenbaum and Mina Strickland. For the record, my name is Dave Fiscum. I'm the current chair of the Oregon Government Ethics Commission. How we're going to proceed today is fivefold. We're going to hear a report from our investigator on the matters before us involving Multnomah County School District 51J. We may have questions for our investigator, and next we'll turn to you to make comments to us if you choose to make such comments. What we'll do is kind of hold you to a 3-minute time clock for each of you to make comments to us. And what I would encourage you to do is hit the high points for us that you want to hit with us. We may ask you questions, and finally we'll move toward a decision. So that said, we'll call on our investigator to make a report for us pertaining to items 5.1 through 5.5. Commission Investigator Fenstermaker.
Okay, and just for clarification, it's 56, 57, 59, and
Pardon me, 56 through 60. I apologize.
Except for 58.
Right. Thank you. 56, 57, 59, 60. Please proceed. Thank you.
Thank you, Chair Fiscum. Commissioners, I'm Casey Fenstermaker for the record. Agenda items 56, 57, 59, and 60 are preliminary review reports for governing body members of the Multnomah County School District 51J, also known as the Riverdale School District. The complaint in this case alleged violations of public meetings law at an executive session on October 24th, 2024. The first allegation was that the school board improperly met an executive session under ORS 192.660 sub 2 sub F, which allows a governing body to meet an executive session for the purpose of considering information or records that are exempt by law from public inspection. The complaint in this case alleged that the document reviewed in executive session was not an exempt record and did not contain confidential information, and therefore the executive session was held improperly. Historically, the commission interpreted ORS 192.660 sub 2 sub F to require a governing body to be reviewing exempt public records in order to utilize this provision for an executive session. But after review of the statutory language and discussion with DOJ counsel, the recommendation is to move away from that interpretation and toward an interpretation that allows governing bodies to meet in an executive session to discuss not only records exempt from public inspection, but information exempt from public inspection as well. For example, this would allow governing bodies to have conversations with their legal counsel under ORS 192.660 sub 2 sub F without the need for an attorney-client privileged memo from counsel regarding the matter as the basis for the meeting. In this case, the record in question is not exempt from public inspection, but the discussion with legal counsel regarding that record is. Therefore, given the updated interpretation of the statutory language, Commission staff recommends dismissal of that part of the complaint. The second allegation is that the school board failed to take minutes of the executive session. Public meetings law requires either written minutes or a sound, video, or digital recording of all governing body public meetings, including executive sessions. The written minutes or recordings are not required to be verbatim or to be a full transcript or a full recording. However, they are required to give a true reflection of the matters discussed at the meeting and the views of the participants. The statute specifically identifies information that is required to be in the minutes, including the substance of any discussion on the matter and a reference to any document discussed in the meeting. In the instant case, it would appear that the meeting minutes do not include all of the information required to be included, as it lacks the substance of any discussion and does not appear to reference all documents reviewed during the executive session. Based on the information reviewed during preliminary review, the recommendation is to move this case to investigation.
Investigator, colleagues, any questions for our investigator based on her report? If so, please ask them. Hearing and seeing none,
Commissioner Payne has her hand up, or Vice Chair, excuse me.
Oh, pardon me, Vice Chair, I didn't see your hand. I apologize. Please proceed.
Yeah, I have a question regarding the obligation to keep minutes versus the exemption to disclose those minutes. And it seems like in the AG manual and in the statute that for executive sessions regarding attorney-client privilege, my understanding, and I just want to clarify this, is there's an obligation to keep minutes and to record these executive sessions regarding attorney-client privilege, but they would not have to disclose these minutes to the public because they're inconsistent with the purpose for which the meeting was held. And so if there's a violation here, it would be because they didn't keep the minutes, but they would not have had to disclose those meetings to the public. Is that correct, Executive Director?
Correct, yes. Under 192.650, and it requires that minutes or a recording of the executive session be kept, and that the minutes, if they are doing minutes, have to include all the same things that minutes for the public session must include. You know, the votes, the people present, the matters discussed, substance of the matters discussed, the views of the participants. Simply that because it is an executive session and therefore confidential, they're not required to disclose them. The only exception would be pursuant to a court order, or our statute requires that they disclose them to us for a determination, but they would remain confidential unless the commission found that the entire discussion was unauthorized, which is not the case here.
Vice Chair, follow up?
Nope, that answered my question. Thank you.
Thank you. Any questions further for our investigator? Hearing and seeing nobody, no hands raised. This is the opportunity, Ms. Rosenbaum and Ms. Strickland, for you to make any comments you would choose to make to the record for us in regard to the matters before us. Please do so in any order you choose, and I will also ask you to be as brief as you can in your remarks to us. we'll be imposing a friendly 3-minute deadline because of the extent of our agenda today. So and the order of your comments to us can be in any order you choose. So when you choose that, identify yourself for the record and proceed. Ms. Rosenbaum or Ms. Strickland?
Okay, I'm happy to go first, unless Mina, you would like to go.
You can go ahead. Thanks, Michelle.
Okay. Good morning, Oregon Government and Ethics Commissioners. My name is Michelle Rosenbaum, and I'm taking this opportunity to address the meeting minutes in the preliminary report. Since 2021, Mr. Bogarty has harassed me and filed 7 complaints and 15 records requests targeting me and other board directors that do not conform to his views. I'm a biracial woman and the first board chair of color at Riverdale. It is unfortunate to be the target of Mr. Bogarty, and during my current re-election campaign, he has sent communications aggressively pressuring those that have publicly supported me. He has also harassed others in our district that do not conform to his views. I have been diligent in my fiduciary duties to our district by collaborating with our resources and relying on legal advice and board training. And we are fortunate to not be implementing a cuts budget, as you can see in many districts across the state. My diligence also extends to seeking legal counsel and conferring with my superintendent and vice chair before responding to Mr. Bogarty. If I do not respond immediately or in the fashion Mr. Bogarty wishes, he will communicate in a questioning, accusatory, and censuring manner. Regardless, it is important that our board take every complaint seriously and follow policy. With regards to the executive session minutes in this complaint, board directors, including myself, had concerns that the meeting minutes be in compliance. Vice Chair Strickland and I both sought legal counsel's advice on the minutes. We made minor edits with legal counsel to ensure a true reflection of the matter discussed at the meeting and the views of the participants. Legal counsel also has advised us to contact OGEC and make sure the minutes were in compliance. I spoke with Josh Sullivan at OGEC on November 20th for 32 minutes. I went over the minutes and it did not appear that anything was out of compliance. I also sent him the minutes and nothing in his written response indicated concern or the level of detail being asked for in the preliminary report. I forwarded this email to Investigator Fenstermaker recently. I also forwarded the OGEC approved OSBA training that does not indicate that meeting minutes need to have details, such as all of the attorney-client privilege legal advice, as well as all the answers given. If this is the case, our meetings would need to be recorded or transcribed. After attending many public meetings law trainings, including the OGEC approved OSBA training, consulting extensively with legal counsel throughout complaint A, and managing complicated issues around harassment allegations brought by our superintendent regarding Director McPherson, and contacting OGEC to ensure that our executive session was in compliance, I am disappointed this is being recommended for further investigation. I'm happy to change the minutes if needed. However, what is being asked for is bringing up concerns from OSBA, as you can see in their communication yesterday to Susan Myers, and from our legal counsel, who has advised us not to record executive sessions where legal advice and to protect attorney-client privileged information. As to the documents considered under the 2F provision, the confidential information we considered was the attorney-client privileged legal advice referenced in the minutes. Thank you for your careful consideration of this matter.
Thank you, Ms. Rosenbaum. Let's hold off on questions for you and for just a moment and allow Ms. Strickland to make any comments she chooses to make to us. Please proceed.
Good morning, Commissioners. I am Mina Strickland, Vice Chair of the Riverdale School Board, a practicing attorney for over 25 years, a member of the Oregon Bar, and a registered patent attorney before the U.S. Patent Office. I take my ethical obligations very seriously. To support the recommended motion, OGEC has introduced an entirely new executive session meeting minutes standard, exceeding its authority under law, distorting the statutory requirements of public officials, and undermining longstanding attorney-client privilege principles. OGEC recognized that the executive session was proper for receiving recommended legal advice from district counsel, and minutes were recorded, yet contends that there does not appear to be a substantial objective basis to believe the minutes meet the required standards, as they do not include transcription-level details of the questions asked and legal advice provided, which is not required by law. This misinterprets the legal requirements and is an overreach of OGEC's authority, as the language relied upon is simply not found anywhere else in law or policy or manuals. Further, attorney-client privilege is a legally protected right, an important one, and demanding such granular recordation of privileged communications and meeting minutes undermines well-established legal protections. The Oregon AG's Public Records and Meetings Manual, in fact, recognizes the importance of public bodies having access to legal counsel, and that they should be able to, and are indeed encouraged to, engage in private and candid discussions with legal counsel in order to better manage complex legal issues they face. Oregon school board members also have a fiduciary duty to the districts they serve to maintain privileged communications as confidential, meaning not taking unreasonable risks to have that information be available outside of the privileged scope. OGEC's stance risks forcing school board members into a position where their fiduciary duties directly conflict with OGEC's requirements, a real damned if you do, damned if you don't. And it creates an environment where public officials are reluctant, and indeed in this case, the Riverdale school board members are reluctant to seek legal advice at all, fearing being constantly called before the OGEC. The recommended motion also flies in the face of basic fairness. As you've heard, in the grievance, the board was alleged to have failed to take minutes. And however, as you have heard from Director Rosenbaum, the board chair did indeed take minutes, and in abundance of caution, sought guidance from a number of parties, a number of trusted parties, the OGEC itself, the OSBA, district council, a very talented and experienced superintendent. And no one recommended that the minutes needed to contain this level of detail. The board chair followed their guidance in good faith. I urge this commission to take no further action against me or my fellow board members and dismiss the matter. OGEC should then work together with OSBA, school board legal counsel, and public officials to provide clear expectations within the bounds of their authority for executive session minutes. When you have school board members who are ready and willing to meet the legal and ethical standards, there should be a clear path. Thank you.
Thank you, Ms. Rosenbaum and Ms. Strickland. It's time now for the commissioners to ask any questions of you. Before we proceed beyond that, any questions that anybody, commissioners, want to ask of the two respondents today? Vice Chair, please.
Yes, Ms. Rosenbaum, you stated that you sent the minutes to the to staff at OGEC and got them approved, or maybe I misunderstood. Could you explain when that was and who you spoke to?
I spoke with Josh Sullivan. That was in my comments. So I had a phone call with him that lasted 32 minutes. And he replied with, he had a disclaimer. It was, you know, he can't give me advice because it had been after the fact, like checking the minutes. However, we did talk about the minutes at length during that 32-minute phone call. He reviewed the minutes and then he just gave me, I can read the email because it was just very simply, you need to state, I can look it up on the computer if you want.
I have it up if you want me to read that email.
Ms. Rosenbaum, okay. Mr. Sullivan has that email. If you can't find it quickly, we want to proceed.
Yes,
so
yes.
Either way.
Yes, Mr. Sullivan would like to read
Go ahead,
what he
Mr.
wrote.
Sullivan.
So he had the disclaimer and then he wrote what needed to be in there.
Yes, this is Josh Sullivan for the record. It's a brief email response after our conversation on the phone where it just went through some of the statutory requirements for minutes and where to find that and the AG guide and all of those things. Then she sent over some minutes for us to review, and in replying, I said, we can't offer advice because it's a situation that already occurred. And we can't positively say that the minutes you sent are a true reflection of what was discussed since we have not been present or since we were not present and have not listened to a recording. And then I explained the required information for minutes is listed in ORS 192650, and you need to make sure that your minutes identify members of the governing body who are present, identify the purpose of the statutory authority for entering the executive session, and provide a summary of this discussion. Reference the documents considered and indicate no votes were taken. And I hope that's helpful. And then I send her a link for the AG manual so that she can review those requirements.
Thank you, investigator. Vice Chair, any follow-up? Thank you. Any further questions for the two respondents briefly? Hearing and seeing none, executive, please, any response to what you've heard?
Yes.
That would help us. Thank you.
Like to clarify, and Casey might as well. After Ms. Rosenbaum and Ms. Strickland, after we received their additional communications, I went through and went back and looked at OSBA's training, and what Ms. Fenstermaker puts in the report is exactly what OSBA's training says. It says that when it comes to minutes, the minutes must include the views of the participants and the substance of what is being discussed. And that is what at OSBA's training also indicates that's as true for executive session minutes as it would be for public session minutes. And so what Casey put in the report was that the minutes that were produced do not appear to reflect the substance of the discussion or the views of the participants. And that if you're not required to give a verbatim transcript, but you must give more than simply, we discussed attorney-client advice. So Casey provided suggestions of what an additional level of detail might satisfy the requirements.
Thank you. Mr. Brady, any comments on what you've heard? And if you have done, that's fine.
The only comment I would make relates to the fact that you're required to take minutes doesn't waive any type of attorney-client privilege or anything of that nature. And so the bodies have the ability to either record them, that doesn't waive privilege, or take minutes. Those are the requirements in the law, but that doesn't waive any type of privilege that's being discussed or anything of that nature.
Thank you for your comment. Ms. Fenstermaker, anything to add to what's been said in the last moment since you're the investigator here?
No, just that I agree with the executive director and DOJ counsel. Thank you.
Thank you. Okay, colleagues, the time is now for us to move toward a decision on these matters before us, which, just to remind you, are items 5, just to be decided individually, items 5, 6, 5, 7, 5, 9, and 6, 0 on our April 25 agenda. Any instincts about how to proceed? Any comments? Generally speaking, comments? Hearing and seeing none, Vice Chair, Commissioner Thompson, please.
Thank you, Mr. Chair. While I will renew my comment I make about the fact that I hate being dragged into local political issues, I think there are some questions that have been raised around many items that an investigation might help us to clarify for all parties.
Thank you for the comment. I agree with that in whole, but especially the part about the uneasiness of being drawn into what appear to be local political issues where somebody has made multiple complaints to various entities. It's a risk we run on a fairly routine basis, not every time here, but it's a risk we don't like to run, but we have to run it. It occurs in many venues besides ours, but it occurs in ours. So thank you for your comment, Commissioner. Any questions, colleagues, comments? If you're prepared, Vice Chair, please proceed.
Thank you, Chair. I hereby move that the commission find that there is a substantial objective basis for believing that Michelle Rosenbaum may have violated ORS 192.650 subsection 1, and that the commission should investigate accordingly.
Thank you, Vice Chair. Any questions about the motion now before us? Hearing and seeing none, the administrator will call the roll. This pertains to item 5.6 on our agenda.
Commissioner Payne,
Aye.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason, Commissioner Mason,
Sorry, aye.
Commissioner McCully,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
That relates to item 5.6, colleagues. We'll now turn to item 5.7, assuming the discussion has been adequate for our consideration. Vice Chair, please, item 5.7.
I hereby move that the commission find that there is a substantial objective basis for believing that Ali Lanananga, sorry, I'm not sure I'm pronouncing that correctly, may have violated ORS 192.650 subsection 1, and that the commission should investigate accordingly.
Thank you. Item 5.7, the administrator will call the roll, please.
Commissioner McCully,
Aye.
Commissioner Mason,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Turn now to item 5.9. Vice Chair, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Mina Strickland may have violated ORS 192.650 subsection 1, and that the commission should investigate accordingly.
Thank you, Vice Chair. The administrator will call the roll. Item 5.9, please.
Commissioner Mettler,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCully,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Colleagues, item 6.0. Vice Chair, please.
I hereby move that the commission find that there is a substantial objective basis for believing that Jeff Dominitz may have violated ORS 192.650 subsection 1, and that the commission should investigate accordingly.
Thank you, Vice Chair. The administrator will call the roll. Item 6.0.
Commissioner McCully,
Aye.
Commissioner Mettler,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Okay, for Ms. Rosenbaum and Ms., if I'm saying that name right, and Ms. Strickland, please understand that what we have done today does not find there to have been a violation of anything. We have simply moved ahead to conduct, to do more work on our investigation. We'll be in touch with you specifically in that regard, but understand that we have not yet found there to have been a violation. It's under law, our process for ending a review and moving to investigation. Thank you again for your appearance before us this morning. Ms. Strickland, I see your hand up, so please make a final comment and then we'll dismiss you. Thank you.
May I ask a question?
Sure.
Director McPherson was present at the meeting. Why is he not in the same boat as the rest of the directors?
Well, Ms. Strickland, thank you for your question. To use your phrase, he may end up being in the same boat, but he did not waive confidentiality for this limited purpose of this procedure. So we'll consider him separately. That's a requirement for us. So he did not, for whatever his personal reasons, engage in that waiver. We'll move to his item next after dismissing you. Thank you for your question.
Thank you.
Thank you. We will now dismiss you. Our staff will be in direct touch with you in the next days. Thank you for your appearance this morning and for your patience with our agenda. Have a nice weekend.
Thank you.
Okay, we'll exit those people from our process and move to Mr. McPherson or Ferson, however you say his name. And he is going to be participating with us, according to my records, by teams.
Yep, pulling him into the room now.
Please. Mr. McPherson, Can you hear me?
I can. Let me just turn up the volume because I can barely hear you.
Okay.
Perfect. I can.
Please say your name for the record, Kevin McPherson or McPherson?
It's McPherson.
McPherson, thank you very much. Just so you know, my name is Dave Fiscum. I'm the current chair of the Ethics Commission. This is the time set aside for consideration of the matter involving you before us in Multnomah County School District 51J. The process is fivefold today. We will hear a report from our investigator. Secondly, we may choose to ask her questions. Thirdly, we'll hear comments from you. I will hold you to a time clock of 3 minutes because we're on a long agenda today. So just make a few comments for us for the record if you choose to do so, hitting the high points of your comments. Fourthly, we may have questions for you. And fifth, we'll move toward a decision as a commission. That said, the investigator will make a report to us. Investigator Fenstermaker, please proceed.
Thank you, Chair Fiscum. Commissioners, I'm Casey Fenstermaker for the record. Agenda item 58 is a preliminary review report. Kevin McPherson of the Multnomah County School District 51J, also known as the Riverdale School District. The complaint in this case alleged violations of public meetings law at an executive session on October 24th, 2024. First allegation was that the school board improperly met an executive session under ORS 192.660 sub 2 sub F, which allows a governing body to meet an executive session for the purpose of considering information or records that are exempt by law from public inspection. The complaint in this case alleged that the document reviewed in executive session was not an exempt record and did not contain confidential information, and that therefore the executive session was held improperly. Historically, the Commission interpreted ORS 192.660 sub 2 sub F to require a governing body to be reviewing exempt public records in order to utilize this provision for an executive session. But after review of the statutory language and discussion with DOJ counsel, the recommendation is to move away from that interpretation and toward an interpretation that allows governing bodies to meet in an executive session to discuss not only records exempt from public inspection, but information exempt from public inspection as well. For example, as in this case, this would allow governing bodies to have conversations with their legal counsel under ORS 192.660 sub 2 sub F without the need for an attorney-client privileged memo from counsel regarding the matter as the basis for the meeting. In this case, the record in question is not exempt from public inspection, but the discussion with legal counsel regarding that record is. Therefore, given the updated interpretation of the statutory language, Commission staff recommends dismissal of that part of the complaint. The second allegation is that the school board failed to take minutes of the executive session. Public meetings law requires either written minutes or a sound, video, or digital recording of all governing body public meetings, including executive sessions. The written minutes or recordings are not required to be verbatim or to be a full transcript or a full recording. However, they are required to give a true reflection of the matters discussed at the meeting and the views of the participants. The statute specifically identifies information that is required to be in the minutes, including the substance of any discussion on the matter and a reference to any document discussed in the meeting. In the instant case, it would appear that the meeting minutes do not include all of the information required to be included, as it lacks the substance of any discussion and does not appear to reference all documents reviewed during the executive session. Based on the information reviewed during preliminary review, the recommendation is to move this case to investigation.
Thank you, investigator. Any questions for our investigator? For the moment, hearing and seeing none, Mr. McPherson, this is the time for you to make any comments you choose to make for the record. Thank you for being here and for being patient with our agenda today. If you make any comments to us, I will hold you to a fairly tight time frame, but please introduce yourself for the record and proceed. Thank you for being here.
Thank you for the opportunity to present to the board. For the record, Kevin McPherson with Riverdale School District. For a backdrop, I've been with the Riverdale School District on the board for roughly 5 years. And the reason I start there is I've been in a number of executive sessions, as well as public meeting sessions, and more importantly, a number of OSBA sponsored public meetings, law webinars, and workshops. And my understanding of the executive session, specifically under 2F, I do believe that the board violated the public meetings requirement under 2F. I stated this in the public session. I stated it in my response to this board, and I am stating it today specifically. Now, why do I believe that? The substance of Mr. Bogety's complaint was specific to this 47 minutes that was redacted. Mr. Bogety wanted that 47 minutes to be replaced back into the public record. He reached out to the process to the district attorney. The district attorney then ultimately made a decision, and I will quote, hopefully everyone on the board has it. He says that the record of the board meeting containing the critical comments about the superintendent, which is in that 47 minutes, or anyone else, does not serve to exempt the records of those comments from disclosure. So the board knew prior to the executive session that the substance of that complaint was not exempt from public disclosure. Now, the other piece of that I want to make sure that you're aware of is that issue was brought up specifically within the executive session. And if this goes to investigation, I'll explain exactly what happened, but the board knew that issue going in. The board was also aware of that issue during the executive session meeting minutes itself as well. If you also look at the history of this board, we have had 12 2F meetings. We've only had 14 executive sessions. There is a pattern in behavior from this board to simply say, we will bring in the attorney and have a discussion about whatever we need to discuss. So I am of the belief that they violated this. I have a belief as to why it was violated, but it's a continuing habit.
Thank you, Mr. McPherson. Thank you for being here today. Any questions for the respondent, Mr. McPherson, from commissioners? For the moment, hearing and seeing none, the time has now arrived for us to move toward a decision on the matter pending before us, item 6.0. Any comments, further questions? Hearing and seeing none, Vice Chair, please. Item number 6.0.
I think you mean 5.8.
Pardon me. 5.8. Apologies. Item 5.8. Thank you very much.
I hereby move that the commission find that there is a substantial objective basis for believing that Kevin McPherson may have violated ORS 192.650 subsection 1 and that the commission should investigate accordingly.
Thank you, Vice Chair. Colleagues, you've heard the motion. I presume there are no questions about it unless I see a hand raised. The administrator will call the roll. Item 5.8.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Mettler,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. Mr. McPherson, we've made a decision to move forward to conduct an investigation on this matter. Please understand the following. Just for the record, we have not decided there to have been a violation of anything yet. We have simply identified the need for more information. Our staff will be in touch with you. Thank you for your participation this morning and for your patience with our agenda. We appreciate your comments and hope you have a good weekend. Thank you.
Thank you.
Okay, colleagues, I'm going to exercise the prerogative of the chair at the moment and indicate we're going to have a fairly short bio break. With that said, I will recess the executive session agenda and we'll convene in 5 or 8 minutes or whatever, shortly after 11 a.m. Okay, that said, the recess or executive session is now stopped. We will return to the executive session calendar with the authority I read a while ago. That authority still stands to allow us to proceed through executive session matters, starting with item 61 on our April 25, 2025 agenda. Am I right? And Ms. Zink, oh, by the way, what I should have said, just to quickly aside, what I could have said earlier is that we did have a record that a reporter from the Statesman Journal had joined us, a reporter named Anastasia Mason. For all I know, she may still be in the virtual room with us. So she is online, and that's at the moment, for our records, the only journalist with us. Completed it. Thank you.
Chair, for
Yes,
some reason, Teams did not unmute when we came back from the break.
who did?
No,
Teams was not unmuted when we came back from the break. So can you just confirm with our colleagues online, maybe if they heard anything?
I
Uh,
heard nothing.
Vice Chair, did you hear any reports? You did not hear? Commissioner McCauley is shaking her head. Commissioner Mason said no. So the procedure is now to start over, am I right?
yes.
Okay, the procedure is now to start over. Colleagues, can you hear me now? Vice Chair, Commissioner
Yes.
McCauley is nodding her head yes. Mason, I think will hear me. Okay, that said, colleagues, we will quote, start over, unquote, in the best sense of that phrase, whatever that phrase means, and we'll hear a report on item 61 from our investigator, Lion Gallagher. Please make your report again for the record.
Thank you, Chair Fiscom and Commissioners. Pardon for those in the room, for those online. Investigator Lion Gallagher for the record. Agenda item 61 in your meeting books is a preliminary review report for K. Michelle Zink, former records supervisor for the Lynn County Court. The Commission opened a preliminary review on its own motion on December 13th, based on information obtained in a news article and a grand jury indictment charging K. Michelle Zink with multiple counts of aggravated theft in the first degree. Based on the information available during this preliminary review, it appears that K. Michelle Zink, through their official position as courthouse record supervisor, responsible for oversight of financial transactions, including making bank deposits and monitoring fiscal processes, had knowledge of court fiscal procedures and access to cash from court transactions. Further, it appears that over a 4-month period in 2023, K. Michelle Zink may have used this knowledge and the opportunity to access cash to allegedly divert $134,721 of cash payments from defendant bail and court fines from 29 bank deposit bags meant for courthouse bank deposits for their own personal significant financial benefit. Based on the information collected during the course of this preliminary review, it appears K. Michelle Zink may have engaged in a prohibited use of office and failed to disclose conflicts of interest related to the alleged theft of courthouse bank deposits. As such, the recommendations in your books is to investigate whether K. Michelle Zink may have violated ORS 244.040, subsection 1 and subsection 4, and ORS 244.120, subsection 1C.
Thank you, investigator. Any questions for the investigator based on the report you've just now heard? Hearing and seeing none, Ms. Zink did not indicate intent to appear before us, so the time comes for us to decide how to proceed on this matter. And looking for any comments or questions from commissioners in general. Hearing and seeing none, Vice Chair.
I hereby move that the commission find that there is a substantial objective basis for believing that K. Michelle Zink may have violated ORS 244.120 subsection 2, ORS 244.040 subsection 1, and 4, and that the commission should investigate accordingly.
Thank you, Vice Chair. This is item 61 on your agenda.
Make one correction. I think it should be the first one, 244.120, should be 1 subsection 1C, not subsection 2. I apologize if we got that wrong on the agenda.
Okay, I will correct my motion and amend it to find that I hereby move the commission find that there is a substantial objective basis for believing that K. Michelle Zink may have violated ORS 244.040 subsections 1 and 4 and ORS 244.120 subsection 1C, and that the commission should investigate accordingly.
Executive, for the record, that's accurate as a motion. Thank you for your head nod in the affirmative. Questions for the motion now before us? Hearing and seeing none, the administrator will call the roll. Item 6.1, please.
Commissioner Thompson.
Aye.
Commissioner Mettler.
Aye.
Commissioner Payne.
Aye.
Commissioner McCauley.
Aye.
Commissioner Mason.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. Appreciate your consideration all and to the report from Ms. Gallagher. We'll now move to item 62 involving Mr. Herman Bartschiger, who is going to join us by phone. And so we will allow a few moments to elapse while Mr. Bartschiger from down south in Oregon joins by phone.
We have not been able to get a hold of him yet. We have tried calling him, so I think we can.
Can we proceed,
okay with
executive?
proceeding.
Okay. Yep.
Well, this is a matter involving item 62, where our investigator is Mr. Sullivan. So please proceed with your report.
Yes, this is Investigator Josh Sullivan for the record. Thank you, Chair Fiscom and Commission. I'm presenting agenda item number 62. This is a complaint against Herman Bartschiger, the former Josephine County Commissioner. The complaint in this case alleges that Herman Bartschiger may have violated Oregon government ethics law by failing to announce a conflict of interest at a board meeting on December 18th, 2024. The complaint states that Herman Bartschiger announced a vague conflict of interest at the beginning of the meeting before discussing a change to community development fees while he was pending a code enforcement violation. The information also indicated that Herman Bartschiger may have been affected by the new community development fee schedule. As Mr. Bartschiger's announcement did not disclose the nature of his conflict of interest, it appears he may not have properly announced his potential conflict of interest. Mr. Bertschiger stated in his response that he was part of a class of homeowners and the class exception would apply in this situation. However, only the commission can make that determination. It also appears that Herman Bertschiger failed to identify a property he owns at 670 Hunt Lane under question 3 of his statement of economic interests, and he did not list his businesses under question 7 of his 2021 to 2024 statements of economic interest. After receiving the preliminary review report, Mr. Bertschiger did correct his statements of economic interest, making these changes. In similar cases, the commission has moved these SEI cases to investigation in order to issue a letter of education to resolve the SEI violation. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Herman Bertschiger violated the provisions of Oregon government ethics law, and the recommendation is to move this case to investigation.
Investigator, any questions for our investigator colleagues? Hearing and seeing none, Mr. Bertschiger has not joined us by phone yet, to my knowledge. So the time now arises for us to move toward a decision on this matter before us, item 62. Any comments or questions before we seek a motion? Commissioner Thompson, please.
Mr. Sullivan, I assume that assuming this goes to investigation, that you will look at the class exemption and staff will give us some information on that. Because it seems like there's a lot of issues in play on what the class might be.
Yes, we can go into the class exception and look more at that.
Thank you.
And
Investigator, Executive Director, please.
I would simply add on the class exception things, because one, it needs to be a commission decision as to who the class would be and or whether the exception would apply. In those cases, our recommendation usually is, if they have not requested a commission advisory opinion, that we move it to investigation so that we can gather the information for the commission to determine whether all members of the class would be affected to the same degree, etc.
Thank you for that comment. Let me just ask this question. For a class to be determined to exist, that has to be a commission decision following up on staff information to establish the class. Is that our decision to establish a class, or is there some other procedure for establishing a class?
The law says that the commission can establish the class, can adopt rules to establish a class, or otherwise do so. And
then pursuant to that, we would decide if somebody fit or not, if that's a non-legal way to make a point. Once we establish a class, then we have a question of, does this person fit into the class or not?
And then the third question is, and therefore, does the exception apply or not?
Yes, thank you. Any questions about that, colleagues? You're a non-attorney. Me asked a question of attorneys, and that's always a risky procedure, to state the obvious. No offense to attorneys in our midst, of which there are a growing number. Commissioner Metler being the newest one of them. I'm going to be outnumbered pretty soon. Okay, if you're ready for a decision on this matter, I'll be looking for any comments from commissioners before I ask Vice Chair, item 62. Vice Chair, are you prepared to make a motion on item 62? And please proceed. Thank you.
Yes, thank you, Chair. I hereby move that the commission find that there is a substantial objective basis for believing that Herman Bertschiger may have violated ORS 244.0604, ORS 244.0608, and ORS 244.120 subsection 2A, and that the commission should investigate accordingly.
Thank you. Colleagues, any questions about the motion? Thank you, Vice Chair. Hearing and seeing none, the administrator will call the roll. Item 6.2, please.
Commissioner Payne.
Aye.
Commissioner McCauley.
Aye.
Commissioner Metler.
Aye.
Commissioner Mason.
Aye.
Commissioner Thompson.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Hey, colleagues, we'll now move to item 6.3 on our agenda involving a gentleman whose last name I can't pronounce, Anthony
I believe it's Wakua, but I also struggle with it.
Wakua. He has indicated he will be online with us by phone, and so we'll pause for a moment to make sure that happens before we proceed.
We're attempting to call him as well. We've not heard from him.
Thank you. We'll allow a pause for a moment or two to try to access his presence by phone.
There, if you wanted to skip ahead to item 64 while they try to get a hold of.
Sure, because item 64, Mr. Bergstrom has indicated no response to our request about appearance today. So that said, let's move to item 64 for the moment, and this involves a person named Trampus Bergstrom, who's not attending today. Our investigator is Lion Gallagher again. Ms. Gallagher, please proceed. Item 6.4.
Thank you, Chair Fiscum and Commissioners. This is Investigator Lion Gallagher for the record. Agenda item 64 in your meeting books is a preliminary review report for Trampus Bergstrom, former fire chief of the Yamhill Rural Fire Protection District. The Commission opened a preliminary review on its own motion on January 24th, based on the information obtained in news articles and a grand jury indictment, charging Trampus Bergstrom with multiple counts of first-degree theft, fraudulent use of a credit card, and first-degree official misconduct. Based on the information available during this preliminary review, it appears that Trampus Bergstrom had access to a fire district credit card that was assigned to him as fire chief for use for district purchases. It also appears that over a 2-year period, Trampus Bergstrom may have used this credit card for unauthorized personal purchases, including but not limited to a trailer hitch and installation, new tires and suspension, and other vehicle service. Based on the information collected during the course of this preliminary review, it appears that Trampus Bergstrom may have engaged in a prohibited use of office and failed to disclose conflicts of interest relating to his alleged use of the fire district credit card. As such, the recommendation in your meeting books is to investigate whether Trampus Bergstrom may have violated ORS 244.040 subsection 1 and ORS 244.120 sub 1C.
Thank you, investigator. Any questions, comments from commissioners for our investigator? Hearing and seeing none, Mr. Bergstrom is not appearing today, so the time is now for us to make a decision on this matter before us. Any comments or questions first? Hearing and seeing none. Vice Chair, are you prepared to make a motion? Item number 6.4.
Thank you, Chair. I hereby move that the Commission find that there is a substantial objective basis for believing that Trampus Bergstrom may have violated ORS 244.040 subsection 1 and ORS 244.120 subsection 1C, and that the Commission should investigate accordingly.
Thank you, Vice Chair. You've heard the motion, colleagues. Any questions? Hearing and seeing none. The administrator will call the roll. Item 6.4, please.
Commissioner McCauley.
Aye.
Commissioner Mason.
Aye.
Commissioner Mettler. Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Thank you. Colleagues, about item 63, and
We can put them in, they're in the lobby now.
please put Mr. Wakua online. We'll ask him to pronounce his own name in a moment.
All right, they're in the room.
Mr. Wakua, can you hear me if I'm saying your name right?
Yes, I can.
Would you do us a favor first and pronounce your last name for us?
Yes, it is Anthony Wakuha.
Wakua, thank you very much. Mr. Wakua, the time is now for us to hear the item pending on your matter before us. Our first move is to hear a report from our investigator. She'll make that report. Eventually, we'll allow you, Mr. Wakua, to make any comments to us you choose to make. The investigator in this matter is Investigator Andrew McIntyre. Please proceed.
Thank you, Chair Fiscum and Commission. This is Andrew McIntyre, investigator for the record. Agenda item 63 is a preliminary review report for Class Stop County Commissioner Anthony Wakua. The complaint in this case is that Anthony Wakua was faced with an actual conflict of interest at the board's January 8th, 2025 meeting when the board discussed items related to short-term rentals because Commissioner Wakua also owns a short-term rental within Class Stop County. At that January meeting, it appears the board discussed raising both the permit fee for a short-term rental and also imposing a short-term rental cap in an unincorporated area of Clatsop County. It was that Commissioner Wakua did declare a conflict of interest at this meeting. However, he stated that he was part of a class exception and therefore did not have a conflict of interest. And he did state that based on the board's legal advice. So I do want to make sure that that's pointed out. I also want to point out it is up to the OGEC Commission to determine if the class exception does apply. And even if the class exception does apply, Commissioner Wakua would still be potentially faced with a prohibited use of office if he used his official position to financially benefit himself or his short-term rental, and that was not available but for his official position. Based on what was specifically discussed at that meeting, which included Mr. Wakua bringing up potentially charging a tiered structure for short-term rentals and how, and that would be based on specific factors. That could be a perceived attempt to use his official position for either a financial benefit or financial detriment. And then also related to the short-term cap, he did participate in the discussion related to that and advocated for that, and whether or not that action would also be an attempt to use his official position to financially benefit is something that, if this case were to move into investigation, that I would look into further. So therefore, the recommendation at this time is to move to investigation for the conflict of interest and the prohibited use of office statutes based on essentially one, the class exception and whether or not that may or may not apply, and then whether or not these actions may have been a use of office. So thank you.
Thank you, investigator. Any questions for our investigator before we proceed? For the moment, hearing and seeing none, Mr. Wakua, if I'm saying your name right again, if I'm not, I apologize. This is your time to make any comments you choose to make to us. A couple things. First, when you make comments, identify yourself for the record.
County Commissioner for Clatsop County District 2. First and foremost, I would like to thank you, the Oregon Government Ethics Commission, for giving me the opportunity to speak today and for considering this information with your decision. On January 8th this year, I was sworn in as a newly appointed volunteer commissioner for Clatsop County with no previous experience to bring to the table. Going into this meeting on January 8th, I was made aware of the agenda items regarding short-term rentals, and without knowing any other resources, I did reach out to Chair Quayla approximately 1 week prior to the meeting to see what information he could share with me about SDR agenda items and explain my involvement with SDRs. At that time, Chair Quayla advised me to speak to County Council about this and mentioned that he didn't think it would be an issue for me to participate in the discussion or vote on the items at hand as long as County Council agreed. Upon reaching out to County Council Anthony Pope on January 3rd, I explained my situation and was advised that due to this only being a potential conflict and not an actual or certain conflict, that I would be able to participate in these discussions and vote as long as I disclosed this potential conflict. Furthermore, County Council informed me that due to this potential impact affecting a group of people and not just myself, that it would fall under something called the class exception, which I had never heard of. With that, County Council provided me a statement to disclose and educated me to read it once at the beginning of the discussion of these topics. I followed those directions exactly as told. Within a matter of days following that meeting, I was contacted by your investigator, Andrew McIntyre, and informed of the complaint and investigation. Until that point, I had neither heard nor been advised of the Oregon Government Ethics Commission as a resource for issues like this or for seeking advice for topics of this nature. I now fully understand the scope and utility of the Ethics Board, and in the future, if given the opportunity to participate in discussions of similar nature, would seek advice from the Ethics Commission first. I would also like to add, in reviewing Andrew's investigation, there is an error noted as he references an LLC registered to me by the name of PNW Unlimited. However, at no point during his investigation did he actually speak to me about this LLC or inquire about its purpose, function, or history. It's worth noting that my LLC, while registered to me, has actually never done any business, and that the STR actually operates under my father's business. For the sake of transparency, which has been my goal from the beginning of this process, I would appreciate to have that error noted. With that said, I do thank you for your time and consideration of information